Okay, we're going to talk about appeals and Erie. We're going to talk about appeals, some review standards, and the Erie doctrine. Not as bad as you think it is, just bear with me. Once again, just some basic definitions. Let's try to keep everything separate. So the first thing to know about the process of an appeal. Number one, the filing of a notice of appeal occurs within 30 days from the judgment. If you want to appeal, the notice of appeal occurs within 30 days of the judgment. There's one question, not so bad. Generally, if you have grounds for an appeal, you must make the objections at trial about those issues you want to raise on appeal, or you may waive them. So generally, if you know during the trial there are grounds that you're going to want to appeal, you must make objections about those issues at trial, or they are waived. So look for in a hypo, did someone make the objection on a particular issue, or did they waive it by not bringing it up at trial? Law versus fact. Generally, we're talking about appealing a case. Generally, the court is going to look closer at issues of the law versus the facts, because again, generally, the court's going to give greater deference to the facts, right? Who decides the facts? The jury. So as long as everything was okay with their determination of the facts, generally you're not going to be able to set aside their determination of facts unless what? Unless they were clearly erroneous. I'm going to get into that more in a little later, but just again, knowing the big picture on appeals, generally you're looking closer at issues of law than you are at issues of fact. And generally the facts are only going to be set aside on appeal if there was some sort of error that was clearly erroneous. Okay, just a definition, clearly erroneous relating to facts. Again, the harmless error rule. Generally for appeals, again, to set aside an original verdict from an appeal, only going to apply if it would have made a difference. If any of these errors that you're trying now to appeal really wouldn't have made a difference, if they were harmless error, if they really didn't change the outcome, nothing is going to happen. Okay? You're really just going to appeal. When do you have grounds to win an appeal? Can you overturn something on appeal? Is if those errors really would have made a difference. So the harmless error rule says if any of these things you're trying to raise on appeal really wouldn't have made a difference anyway, you're not going to be granted that appeal. Okay? Harmless error rule. Make sure you're paying attention to the facts. The big thing to know about the appeal rules are that you can only appeal after a final judgment. A final judgment. Issues that are finally have a final judgment can then be appealed. Until and unless there is a final judgment, there's no appeal that is allowed. Final judgment rule. That is your big definition to be aware of. When can you then go and get an appeal? That issue must have been the result of a final judgment. And that means all issues were finally determined by the court. Once the court makes that final judgment, then you can go get an appeal. If there hasn't been a final judgment as to all those issues, an appeal will not be granted. Except we have your definition. One big exception to this is called the collateral order exception. The collateral order exception. This is when an issue is unresolved. Okay? An issue is unresolved. So generally, can you appeal it? No, based on what I just said. So if an issue is unresolved, it still may be appealed. It still may be appealed if the order determines a right that is collateral to the main issue. Collateral order exception. Here's the couple of elements we're looking for where the collateral order exception will apply when a so-called unresolved issue can actually be appealed. Here we go. The three requirements for the collateral order are: the order conclusively determines the disputed issue. Conclusively determines the disputed issue. 2, it resolves an issue that's completely separate from the merits of the action. It resolves an issue that has nothing to do with the basic merits of the underlying action. And any delay would cause incurable damage. Any delay in resolving this now would cause too much damage. If those elements are met under the collateral order exception, can you then have an appeal from this order? Yes. So generally, all issues must be resolved as a result of a final judgment. What happens if some orders are unresolved and an order may be appealed if the collateral order rule applies? What kind of issues would then fall under the collateral order rule? Anything that would then be conclusively determined. It has really nothing to do with the underlying case, and any delay would cause too much damage. So basically it's like, look, let's just get this thing out of the way now and separate it from the underlying case. You with me on this? Appeal, you can only appeal something that already has a final judgment. Final judgment rule, you pay attention to the facts. What if some issues are not resolved? If an issue is not resolved, then you look to see if the collateral order exception applies. And then an order may be appealed if the order finally determines a right that is collateral to the main issue and the delay would cause severe damage. What is that issue going to look like? They have to tell you in the facts. So you single out that issue, and if you see the term collateral order, aha, that's one where it's a little unresolved, but we can take that issue out, and since it's separate from the main issue, and any delay would cause a lot of damage, that will fall under the collateral order rule. Good? If you have a separate rule, separate issue, if you have one claim in a multi-claim suit, and one claim is resolved, the judge orders a final judgment on that issue. Even though there's other issues to be resolved, you may appeal the final judgment of that issue. So again, just to try to separate these things. We have a multi-issue claim. We have one little issue that has been resolved. There's been a final judgment. Can you then appeal that particular issue if there was a final judgment on it itself? The answer, yes. The answer is yes. There's no reason to delay because that would cause damage. Collateral order is just if there is an issue in a case which is totally separate from the underlying merits of the action. Totally separate, and it's going to be totally resolved, and any delay would cause damage, then the collateral order rule would apply, and that you could then appeal from that order. Injunctions. There's a separate rule just for injunctions. Separate rule for injunctions. And that is that injunctions can be you can appeal the granting or denying of an injunction before all the issues are decided. So if you see that the court grants or denies an injunction, are you waiting for the end where all issues are resolved, John, with a final judgment? No. If you see an injunction in a hypo, you know, all right, ding, 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 even though all the issues haven't been resolved, if you see them testing you on injunctions, then that can be appealed, the granting or denying of an injunction. Just a separate rule all by itself. So again, for the appeals, you're looking for, was there a final judgment or not? If there is, then you can appeal. If a particular issue in a case, or if one issue in a multi-claim case can be resolved on its own, then can you appeal from that order? Can you appeal that particular issue? Yes. Keep those separate. Lastly, we talk about the levels of review, the standards of review in an appeal. Standards of review. We talked about if and now on appeal, their issue is findings of fact. If findings of fact are on appeal, the standard will be clearly erroneous. Were the facts decided clearly erroneously? If the matter on appeal is an issue of law, then you're looking for the so-called de novo review. De novo review. Any issues on appeal relating to facts are going by the clearly erroneous standard. If we're talking about issues of law, we're talking about the de novo review, just a term of art. If we're talking about issues of relevancy, prejudice, court orders, i.e. things the judge did, judge grants makes decisions based on relevancy, orders, prejudice, anything relating to what the judge was doing, court decisions, the judge court decisions, that standard is going to be based on abuse of discretion. Did the judge abuse their discretion? So if you have a hypo kind of testing you on what standard of review, now the case is on appeal, what standard of review will the appellate court apply? You go back and you ask yourself, well, what is the issue at hand? If it's based on facts, clearly erroneous standard. If it's based on law, de novo review. If it's based on anything court order, relevancy, any kind of prejudice, anything the judge or the court did itself, that's going to be based on abuse of discretion. And again, this is just fill in the blanks, people. The facts have to tell you. They may give you a couple of different choices with all these different reviews. All you have to know is, based on the facts, which standard of review is the case about. And plug in your definition. That's all this is about. Lastly, is this matter of the choice of law, federal versus state, and the Erie doctrine. I know we all hate this stuff, so as usual, I'm going to try to put it into clean, quick, crisp way to look at it, and if you see any of these scenarios, this is what you pick. What is going to be your generic hypo that you're looking for? It's a diversity case. Federal court, diversity based on diversity. Okay? That's your hypo. And now there's a choice between the federal court applying federal law or state law. Okay? You're in the federal court. It's a diversity case. The question is, are you going to apply federal law or the state law? Remember, there's no conflict here between federal and state. If there's a blatant, overt conflict between federal and state law to be decided, who always wins? Federal. That's exactly right. Supremacy clause. But usually in these cases, there's not a conflict. Here, there's just a choice between should we apply federal law or should we apply state law. In a diversity case, where there's a choice between federal versus state, you always apply the substantive state law. Always apply the substantive state law. When in doubt, you always apply the state substantive law. You only apply federal law when it's procedural. When the issue is procedural, then you apply federal law for any procedural matters. Anything substantive, you always apply the state law. And that's why I say when in question, always go with the state law. Federal rules, you see something blatant, and I mean blatant, about issues of federal rules, procedure, federal rules of procedure, then I will apply the federal rule, not the state rule. Almost anything, it's going to be close. You pick state substantive law is applicable. Statute of limitations. Any issue or choice of which law about statute of limitations, that is going again to be based on state substantive law. Any decision based on which statute of limitations to apply, you default to that state substantive law. That's the choice of law you apply, the state. If, however, you're talking about a venue issue, a procedural venue issue, which rule to apply, if you see any choice between the venue question, that is considered procedural, and you will then pick the federal law. So it's just a couple of exceptions. Diversity case, you generally always apply the state substantive law. You only apply federal law for procedural matters, procedures. Literally, federal rules of civil procedure. If you see there's a choice there and the case, the issue in the case is about some sort of procedure issue, I'm picking federal law. If it's not, I'm always going with the state law. That's just the way you're going to clear up all these stupid hypos. If you see anything relating to a venue, choice of venue, for some reason they call that procedural, so you pick federal. Statute of limitations, you always go with the state law. Cookie cutter definition. If you have a conflict between the law of two states, not federal and state, you have a conflict of the law between two states. Where again, we're in a diversity case in this scenario, right? I'm from Florida, you're from New York, diversity, and now we have a choice. Do we apply Florida law? Do we apply New York law? Not federal versus state, just two states. Which law do you always apply? You always apply the law of the rule of the state where the federal court sits. Where is the federal court now that we're in the case? Is the federal court in Florida or is it in New York? And when there's a choice between states, you always apply the federal law where the federal court is sitting at that time. So again, easy. See the diversity case. See in the facts that they're trying to choose between. The issue is about whether a federal or a state law is going to be applicable. Always basically you're defaulting to state substantive law. You're only applying to federal law for procedural matters. Literally, it has to be blatant that they're asking you about rules. And statute of limitations will always be based on state law, and anything related to venue, that would be another example of federal. You have a hypo where they're choosing between two state laws, New York versus Florida. You always pick the law that will apply based on the state that the federal court sits. Could you have to do a couple of these hypos until you see what some of this looks like? Yes, but as long as you get your definitions down, you keep it clean and crisp, and then you apply it to a couple of these hypos, even if you get the first few wrong, and at least see what's going on. Don't rush to do another 50 questions before you figure out where is the difference in facts that you want to pick up. And once you see that, everything else will fall into place. And this Erie thing actually isn't that bad. Just make sure you see what the hypo looks like. Everything is based on state substantive law. Unless it's procedural, then you pick federal. If we're talking about a choice between state law, then you always pick the law based on the state where the district court is sitting at that time. Keep your definition separate. Don't be intimidated. It's still just a definition, and every question is only worth 1 point. Keep your eye on the big picture. Get the questions you can get, and don't worry about the little minutia stuff. If you don't like this stuff, keep it simple to a definition and learn how to apply it in a fact pattern. If you like this stuff, don't litigate it. Don't apply your own real-life stuff. Just see that they're testing you on one issue at a time. One issue at a time. First, you have to identify what's the issue. How do you know that? From the facts. And once you see what that issue is and you know what rule to apply and you see it in an answer choice, shut up and pick it.